court entered pleas of true in a motion to revoke probation to counts 1 through 4 on probation for aggravated assault causing serious bodily injury, and that was a 6-year deferred probation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report? Are there any additions or corrections? And there was no agreement, correct? Agreed. Also, just for everyone, and we can get copies if you guys need it, I am also reviewing jail incident reports as well. Mr. Rojas, you may proceed.
Give an opportunity to press, but I still want to influence. You know, don't count. She hasn't taken advantage of all those opportunities. She's going on, trying to do a double.
Third motion to revoke. That number matters. Courts are built on second chances, but not unlimited ones. Each prior violation chips away at credibility. By the third attempt, the court isn't asking, can she succeed? It's asking, why hasn't she? This is the moment when patience starts turning into consequence.
Double challenge class. I was trying to just that. Court has or try one more time against discussions with court smart and get your rules not having as possible for insurance. Feel that and I well, she was the last time she's going to not very much, but we can see the front account for it. I will
Ms. Malfino?
I concur with that. So that's the PSI very thorough, use every opportunity individual has been given by the court. Shane, who doesn't want help, I can help her. Use the last time when she was pregnant, she's not somebody who has to be addressed. If she doesn't want to help, she can get someone else who wants to help. Alright, so those cases work it and she never
I mean,
Texas in the land she's a bottle for sessions. Nobody was injured just.
This is a classic courtroom dilemma. The defense leans on mitigation. Children, CPS cases, life instability. And those factors do matter. But here's the hard truth. Mitigation explains behavior. It doesn't excuse it. Judges have to balance compassion with public safety. And when violent conduct is involved, sympathy has limits.
well, she threw the bottle attempting to hit someone else, but it hit someone, but it hit someone else. Well, there's no accidentally. You meant to hit somebody with it. You just hit the wrong person. Right? No. No, because Ms. Johnson, you have been coming here now way too long and been given every single opportunity to stop talking over me. Because right now, what you're looking at that I can do is give you between 2 and 20 years in prison. And the more you talk over me and are disrespectful, the higher number that's going to get. Do you understand? You have been, I'm not even sure how many times now that you've been in here pregnant, using drugs while you're pregnant, while we're trying to get you help. You have 5 kids that you have no custody of. Jail incident reports are ridiculous, and then you want to come in and say, I just want to get this over with, give me a couple years in prison, which you probably have credit for, which is absolutely not what I'm going to do. Give me just a second. The fact that this is kind of your fourth shot at it makes me wonder what I was thinking the prior 3 times. Really. All right, Ms. Johnson, this time I'm going to find that you pleads are true to counts 1 through 4 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault. I'm going to sentence you to a term of 12 years in the Institutional Division of the Texas Department of Correction. You will receive credit for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in your case. I'm handing you the trial court certification that shows this was not an agreement. You do have some rights to appeal. You can talk to Mr. Rojas about that. I'm also handing you the trial court certification.
This exchange is subtle but devastating. The judge cuts straight through the argument. Intent doesn't disappear just because the wrong person was hit. In criminal law, attempting violence is still violence. And when a weapon, bottle, or knife is involved, the court's concern skyrockets. This is where the tone of the hearing shifts.
It means a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment and provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Rojas. Good luck to you. You can go back with the bailiff. Ms. Thomas, you may proceed.
Thank you, Your Honor. As the court can see, Mr. Jellicoe is an entity, when she testified a few years ago. Your Honor, we're requesting if the court will consider probation. I believe that Mr. Jellicoe will benefit from a mental control. Just suffer from some issues of issues that be cared and for the time. He understands that there have prior convictions, so I feel like the statement to the firearm. He understands that moving forward, no matter what the situation is, like firearm. Your Honor, he does have children that he would be involved in their lives. One of the main issues that I see in the PSR is education. He has great education. I think it would also benefit if he would be allowed to participate in the DD program, the probation department as well, to help him to develop his skills, so that he can make better decisions and get his high school, at least yellow high school equivalency. For substance, with regards to substance use, just like maybe alcohol, that he drinks on occasion, and he has no problem with things to avoid any association, focusing the action say, and as I say to Your Honor, he would be willing to adhere to any response or treatment plans or directives.
This is one of the most dangerous moments for any defendant. Talking over a judge isn't just disrespect, it signals loss of control. And judges are trained to notice that. When the court says 2 to 20 years, that's not a threat. It's a legal reality. Every interruption narrows the path toward leniency.
That probation may recommend for New York probation.
Ma'am. Snuggles.
Your Honor, yes. One. If not, that's one result. Yeah. I don't know the exact
I'm sorry.
Mr. De La Rosa, you wanted to say something? So, in 2015, you were not a juvenile. That was your conviction for unlawful possession of a firearm by a felon. And you got a 2-year sentence. Right. So you should have learned. Not that you can't possess a firearm. I mean, and Ms. Holmes is doing the best she can, saying that, you understand and that you can't possess a firearm, but you've already gone to prison for that. So well, and I understand. Well, here's the thing, Mr. Delarose. Nobody wants to get thrown in prison. What I do today isn't anything that I'm doing. It's where you've gotten yourself with your history since you've been a juvenile into being an adult, knowing that you cannot possess a firearm. You've got 3 prior felony offenses. One was when you were certified as a juvenile, that first one. And then if you didn't understand the law about deadly weapons, you should have, or carrying a firearm, you should have back in 2015. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. I'm going to sentence you to a term of 6 years in the Institutional Division of Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody, but the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, we know this now. I'm required by law to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
12 years. Right in the middle of the sentencing range. That's not random. That's deliberate. The judge rejected both extremes. Not the minimum requested by the defense, and not the maximum allowed by law. This sentence reflects a conclusion the court has reached after years of chances. Rehabilitation was offered and repeatedly refused.